Greetings, everyone. So welcome to our webinar for Thursday, April 16th. So happy to be with you all. So it is a warm and balmy pre-spring day after tax filing deadline. So I hope everyone has done well and has completed their taxes timely. Alas, of course, the deadline was yesterday, so it is what it is. So hope that worked out well for everyone for this tax season. I hope it was smooth for everyone. So we have an interesting topic today. It's kind of a broad topic, a large survey topic today about estate planning for large estates and some various tools for what we can do for estate planning for large estates. So I'm Michael Lee. I'm one of the attorneys in the office, and we do estate planning for, of course, estates of all sizes, but particularly large estates. So this will be our webinar for today. As I always must have a caveat or a sort of disclaimer here. Actually, if we could go back one slide here to our intro. This is for informational and perhaps maybe even entertainment purposes only. This is not legal advice. Please do not engage in large property transfers because you saw some guy on YouTube do this and recommend it. This is really for academic informational planning, really, so we start to understand what these things are, and we say maybe this may be right for you. Is Zortrax right for you? I don't know, but you go see your doctor. Is a charitable lead trust right for you? I don't know, but it helps if you understand a little bit of it. So when you go and speak with hopefully me or whomever, you are informed and you are an educated legal consumer so that you know, does this work or fit for me? So let's jump into our agenda and what we're going to talk about here in our hour. So we're going to define what is the large estate. This has changed a little bit since 2005. This is something that somewhat moves around, and it mainly moves around based on the national estate tax exemption amount. If you want to get really technical, it's actually the credit amount, but it leads to an exemption amount. But there are some variations for varying state law systems that we'll talk about. We'll then talk about some trust structures for wealth preservation and efficient transfer of wealth from generation 1 to 2 to 3, and then sometimes actually even from generation 1 to generation 0, and then around to generation 3. We'll talk about that as well. We'll talk about some gifting strategies and valuation. Gifting is more attractive now with the higher exemptions. We'll talk about some international and cross-border planning because I've seen some problems with this recently, and this has become a little bit of a challenge. So something to take a look at if it relates to you, to take a look at. And then a few things that also on our last thing, number 5, some large estate administration issues that I'm still seeing around there, and some misunderstandings that I'm seeing. And sometimes these misunderstandings are like really significant misunderstandings. So we'll get into that. So we'll just have at it. So let's move on to slide number 1, defining the large estate. So we are in the one big beautiful bill era. For as long as that lasts, for as long as anything that Congress creates. The old idiom, what Congress giveth, Congress can taketh away. Well, Congress has given us this one big, beautiful bill. This came about in 2025 and solved the problem that we had been talking about. And if you've been joining our webinars for a while, this question of, well, how big is the individual estate tax exemption? And is it permanent? Permanent is always in quotes, but is it permanent? Is there some timer set on the law, or is it just a number? Well, we got the answer. Under the One Big Beautiful Bill Act, it is established as $15 million per person. It is also, because it is per person, if we have a married couple, person 1 and person 2 can be together. And for spouses, it is portable. So if my spouse passes away and she has the 15 million left over, she can pass that to me and I have 30 million. So the One Big Beautiful Bill Act is the reality that we are in. Fun fact, because I like technology and I like to play around with it, AI is a little bit behind on this. And a lot of the AI training models, I guess their neural network that they're doing is always a little bit behind. So the closed network is a little bit behind and then it goes onto the internet. So be careful. I have a lot of clients sometimes will AI up something to me and send it to me and say, Mike, what do you think about this? And every once in a while, I take a look at it recently from some of this AI generated stuff, and it's one cycle behind, and it will say, well, under the Tax Cuts and Jobs Act, there's a sunset, or the Tax Cuts and Jobs Act, it's 10 million and it's going to revert. That's not the law anymore. You're a little bit behind. It's one big beautiful bill act, $15 million per person. As a married couple, it is 30, and it is transferable. Asterisk. Married couple, and the married couple are each citizens. It is transferable if you are a married couple and you are citizens. If you are permanent residents, or one person is a permanent resident, it works a little bit differently. It's not transferable in the same way, and it sometimes does not transfer the same way directionally. So if I'm the citizen, passing it over to the non-citizen, that is problematic. So if you have a blended family, it's something to, and by blended family, I mean blended citizenships, it is something to take a look at, because the individual exemptions work for the year that the person passes away, but things like the marital exclusion between you and how you claim the exclusion is different. So we are now in the era of $15 million per person. Great. We have the ability to have portability. Great. But remember, it is for citizens. If you have blending, we got to take a look because it varies. The other thing we need to take a look at, and if we have any friends on here that are from Washington State, because we also practice in the state of Washington, it is different. So if you are in states that have their own state level estate tax or state level inheritance tax, again, we need to take a look at that. So if you are from Washington State, you may say, "Oh, as a couple, we're okay. We're at 16 million. We're way under. We'll be just fine. Providing the law doesn't change. This is great. No problem with the estate tax. No problem with the federal estate tax. You're going to have an issue with the Washington State estate tax, because that can be as low as 2 million per person, and they don't have the portability system. You have to settle it up, and there's different ways how you do that in so year over year, how you adjust that. So if you have domicile, if you live in Washington or you live in another state, then let us know, because there is a state element here. If you're one of our California friends on here, California friends, congratulations. This is one tax California doesn't have. California does not have a state level estate tax, nor a state level inheritance tax. Be careful. Some states like Minnesota have both. State levels estate tax, the person dies, you tax that estate. A Minnesota person inherits, you tax the flow of money into the inheritor. We don't have either, but be careful. Also be careful if you have real property in a state that has estate tax. So if you say, "Oh, Michael, I don't need to worry about that. That's totally irrelevant to me. I don't live in Washington. I live in San Diego. I just, spend all of my, summer in Washington, and then the rest of the time I spend in San Diego. And when I'm in Washington, I spend my time in my $5 million Washington house." Watch out. You're not in Washington, but that property is. Real property is there. And that will be triggering the Washington estate tax. So even though you're not there, if you have real estate in a state that taxes for estate tax, you're caught there too. Maybe your real estate is under $1 million, then no problem. Then you're going to be under the cap. But if something happens to you, you have to address that with an estate tax return in that particular state. So state level considerations are an important thing to take a look at if you have multi-state connections. The other thing to consider now with these higher exemptions, and where a lot of planning is being mulled over, is now with these higher exemptions, there is greater wiggle room for effective use of the exemption. So effective use of the exemption is that because it's so high, if I'm a $10 million estate and I was considering to do an asset protection trust or give something to my children or things like that, it's much easier to do now because I don't quite have the trade-offs of saying, well, there's the value of giving it to them early, but then it hurts me because it uses a lot of my estate tax exemption. Maybe that will cause a state tax later, that sort of calculation. We now don't necessarily have that. So considerations where there may have been an estate tax element, there is an issue that one has to, or there's an issue that we don't really have to be so concerned about because we have these more generous exemptions. So let's move on to our next slide, slide 2, because we kind of get the lay of the land. What are the common trust structures that people use? So you'll look at this and like, it's a wall of text. Well, this is a preliminary toolbox of generalized things that people use for high net worth planning and are common practical choices. The one that I would say of all of these 6 that is really most commonly done and is used and has the most flexibility and the most practicality is the IDGT, the Intentionally Defective Grantor Trust. And this Intentionally Defective Grantor Trust, the reason I like this is because it is so flexible and it can really be designed to fit you and what you're trying to do. I often talk about this personal history of mine of years and years ago when I was in college. I worked as a dry cleaner tailor and got pretty good at it, I guess, being able to tailor clothing, oddly enough, particularly men's clothing, because it's easier, but got decently good at it. And I laughed that my job really hasn't changed from nearly 30 years ago when I was in college. My job is to make things fit, to adjust things and make sure it fits the particular client. And the IDGT I like because it is flexible. Let's go into the details. Why is it flexible? Well, why is the IDGT flexible? Well, generally, the IDGT is designed as a grantor trust. That's the intentional defect. We create a defect of, let's say, a substitution power or add a charitable beneficiary power, or we add a power that causes it to be a grantor trust. What does that mean? It basically means I can grow the plant, but I don't have to pay for the water. Or I should say, I pay for the water. The plant doesn't have to pay for the water. So I can grow the fruit, and the people who eat the fruit don't have to pay for the water. What do I mean by that? The Intentionally Defective Grantor Trust, the box, I can create the box. I make the gift into the box of $100,000, and we're just going to keep it simple. $100,000 is in the trust, and it earns interest. And it's earning interest and earning interest. Well, as of yesterday, it was tax time. The trust has to pay its taxes. Well, if it earns interest and it earned $3,000 of interest, does it then have to account for the $3,000 of interest in the box? And of the $3,000 ahead, does it have to pay, let's say, $1,000 to the IRS in California to settle its taxes? IDGT, no. It has $103,000 in it. Well, what about the tax bill? Where does the tax bill? Tax bill comes back to me. Comes back to me as the grantor. And says, Mike, on that IDGT, it's attributing the $3,000 of income to you. You got to pay the taxes on that. It's $1,000. I pay the taxes. So the growth of the IDGT increases, of course, from the income, from the interest, but it doesn't get, so, two steps forward, one step back. It doesn't have that problem because I pay the taxes on that. And so the fruit grows, but the water is paid for by me. And that paying the taxes of the IDGT is not an additional gift to the IDGT. So I can grow it, and that's not considered an additional gift. So that's great. It seems counterintuitive. A lot of people hear this and they say, wait, why would I want to pay the taxes on the IDGT? I say, well, let's go back to first principles. Why are you doing the IDGT? They say, well, because my estate is too large. That's why. Because you can move the piece out into the IDGT. That can, of course, grow. It will pass costs back to you. You pay those costs, but those are not additional gifts. You grow this box, and you shrink this box. That's the intention of the IDGT. Very, very flexible. Of course, we can also build into the IDGT, in case of certain situations, it can reimburse you for the taxes. So if there's a year that it incurs a lot of taxes, it can reimburse you. Also, with good portfolio management of the IDGT, I gave the example that it was doing interest. That's probably not the most efficient investment design for an IDGT. You probably would want to do capital growth and capital gains because IDGTs, you generally can get a lower, well, any investment, you're going to get a lower effective rate on the capital gains sales than just straight interest. So that's the taxation of the IDGT. It's also very flexible in terms of design. I can have it where my children are fixed beneficiaries under a fixed standard, health, education, maintenance, and support. And so I put the $100,000 in there, and I say son and daughter are the beneficiaries, 50-50, and it can disperse on the HEMS standard, and that will work. And in fact, I could even be the trustee of that trust. That could be a completed gift, and I could monitor the trust for them. That will work just fine. That works well, and I could start doing annual gifting. I could do large gifting. I could do all kinds of things by putting it in there. I can also make the IDGT, how flexible it is. I could also change the distribution when I create it. Of course, this is part of creation, and make it a dynasty style trust. And say, well, I don't want it to be son and daughter because I'm a higher net worth family. I also want more flexibility. And also, my kids are young. I don't really know what they're going to do. I want it more open-ended. Okay, we can use the same backbone of the trust as the IDGT, but we will make it as a dynasty trust. We generally will need to seek the law of Wyoming or Nevada, of course, two places we also practice, because their statutes particularly allow and specifically permit the dynasty trust to exist. This complicated thing called the rule of perpetuities in both Nevada and Wyoming are extended. Wyoming, 1,000 years, Nevada, 365 years. So a long, long time. You would use generally a trust company or a trust service out there, and you would have the IDGT structured under that law, and you would have the dynasty provision. It would say, to the blood heirs of Michael Lee forever. And then I have a dynasty trust, IDGT trust plus the dynasty trust. We can combine those two concepts. We could even combine the thing above that, the DAPT, Domestic Asset Protection Trust. We could further beef up the trust by saying it's going to be an IDGT with dynasty distributions, and it's going to be structured on perhaps Nevada's very, very strong asset protection law, very, very strong if it is a third-party trust. Nevada also permits self-settled trust, but California doesn't. There is a case out of the Eastern District where this is potentially complicated in California if you're using California real property. But if you're giving it to your children, the dicta in that case, it looks quite good. So you could combine IDGT with dynasty provisions and the Nevada asset protection features to have a very, very solid, safe trust that would be very, very hard for creditors to get into. So I can combine these different, quote unquote, different trusts. They're not necessarily different trusts. They're different provisions. They're different styles of trusts. The same way we did this IDGT Dynasty Domestic Asset Protection Trust. I'm thinking of I'm Mike Lee giving it to the trust and the beneficiaries are my children. I could even do this. I could combine IDGT, SLAT, SLAT, Dynasty, and maybe even Domestic Asset Protection Trust if the beneficiary is my wife. And so I say, okay, I'm going to put this asset in. It's going to be for my wife during her lifetime and then my kids thereafter. We could potentially do that. The problem, though, and I see this a lot of financial professionals recommending the SLAT, um, and always a consideration for the SLAT, is the SLAT is not as easy as it seems, though, in California. When I teach this as a class at the law school, I always ask why, and I look around the room, why is the SLAT not as easy in California? And sometimes there's just silence, which is pretty common. But sometimes I have a lot of hands go up, and the students recognize the problem right away as they say, Professor Lee, I know what it is. And I said, why? I said, because we're a community property state. How do you get the property into the SLAT if I, wife, already own it? Isn't that a self-settled trust? And doesn't California, specifically in the probate code, not permit self-settled trusts? Say, gold star for the day for you. You're right. That's the problem. California, Washington state also are community property states. And if we have a situation where we're doing a SLAT, there's a problem if we just have a brokerage account, et cetera. And we say, yeah, let's do this SLAT. This will be a good idea. And I, husband, will create the SLAT for wife. Yeah, this is great. Well, when did I accrue the funds in that brokerage account? I said, oh, yeah, I don't know, last 5 years. And how long have you been married? 15 years. That's community property. I said, no, Mike. It's in my own name. That brokerage account has my own name on it. See, it's mine. It's from my stock options and things from work, but it's got my name on it. See, it's mine. No, it's community property. The title doesn't mean anything in California. In Brace made that very clear. It depends when and how you accrued the asset. So that brokerage account is likely community property. So if you're doing a SLAT and doing it properly, you're going to have that brokerage account. And ironically, your wife is going to have to then you and your wife, or you and your husband, or you and your spouse are going to have to do a transmutation agreement and make that not community property and make that separate property. And you're going to have to do that in a way that is kosher under the family law. You could do it gratuitously. It's usually better to balance, but you could do it gratuitously. Doing a transmutation generally requires your spouse to have separate counsel. So there's a whole element of this with the SLAT in California that is a little bit more involved than what most people assume. I have a lot of people come in and say, oh, I talked to my financial professional. They said I should do a SLAT. I said, okay, tell me what they said about it. And this issue is just not conceived of because it's not on the sort of glossy advertising things that they hand you at the brokerage. It's because of the community property issue. And they say, well, why, if that's such a big thing, why is it not on the glossy brochure that they gave me? Only 8 states are community property states. The other 42 states are not. So it's actually in the majority of states not an issue. Also, of the 8 states that do community property, the 8 states do it differently. So you can't even really say, well, the rule for community property is this, do this, because different states do it differently. So you'd have to have many different flyers and many different pamphlets, state by state by state, for only 8 states. So they tend to not go down that road. SLAT can be a very effective asset protection tool. It can be a very good estate planning tool, but just be aware that there is this family law element in California, Washington, and the other community property states that we can't really just follow that sort of pamphlet that they give you and just do the SLAT because there's a property ownership issue. Moving right along, if we couldn't make this more complicated, thinking about these trusts, this box, we've been thinking about the design of the box, who's the beneficiary of the box, who's controlling the box, what state the box is in. The other thing we need to think about is how do we get stuff into the box? How do we get things into the box? Well, the easy way is I just gift it into the box. I just say, I have $10 million of assets, plus my house, which is, $2.5 million or something like that. So I'm like $12.5 million with my wife. I say, things are going to be good, but we're probably not going to be, not $30 million good. It's, going to be, maybe 20 or so, over the years. And the kids are, adults and they're growing up, and, I want to start, giving money and seeing them, enjoy some of this now, and I want to do it in a tax efficient way. I want to start, doing the gifting. Well, great. With the high exemptions, we can just gift. I could just slide over 1 million or 2 million into the intentionally defective grant or trust for the kids. Why do I want to do this instead of an outright gift? Maybe because I don't want the kids to have total control over the asset. They're maybe still young. I say, yeah, they're adults, but they just got married or they're going to get married. They work in a risky field, risky field like oil, offshore oil drilling. No, not risky field like offshore oil drilling. Risky field like they're an oral surgeon. They're an ophthalmologist that practice, out of a retina center. They shoot lasers into people's eyes to fix their retinas, and miraculously people are able to see. That's a very dangerous job. That's a crazy dangerous job, even though it's a great gift to society. Something could go wrong. You practice out of your own clinic that you own, and of course, you carry malpractice insurance, but it's really risky. So maybe even though my son or daughter is saving people's sight every day, actually I need to be a little careful with her inheritance, even though her job is so illustrious and such a great benefit to society. It is risky, and she might get sued. And gosh, if you get a lawsuit and say you committed malpractice and I'm now blind, that's going to be a huge lawsuit. Even though you said you think risky profession, you wouldn't think that, but that's one of them. So thinking about that, I want to do the gift through a structure like an irrevocable trust. I could just do the outright gift, no problem. That works great. But as always, if you want this to be more complicated, I can always make this more complicated. How can we make this more complicated? Well, what if I say, well, what I want to put in there is concentrated securities in a famous tech company, because I have a lot of that. I have so much of this tech company stock. I want to put that in there because it may really increase in value. Who knows? I want to move that over there. But, I only have, let's say $1 million worth of shares of that. I'm worried that it might become 5 million. And I kind of want to keep the million though, because like I don't have like, I'm not like super wealthy. I don't have like $30 million. I have some, but and I kind of like to keep it. But I don't need, if we're at 10 or 12, I'm happy. I don't need to be 18, but I do kind of want to stay 12. How do we do that? We can do that. How do we do that? Sale to an IDGT or do a GRAT. What do we do with that? What do I mean by this? We can take the $1 million worth of shares, we can sell them to the IDGT or contribute them to the GRAT, and the IDGT and GRAT pays us, either GRAT is an annuity or the IDGT pays us via the note. Essentially, let's say 5 years, it will pay us $200,000 plus interest in shares. It doesn't sell the shares. Keep in mind, it doesn't sell the shares. I put $1 million worth of shares, and then it transfers the $200,000 plus interest in shares to me annually over a 5-year period of time. And what the hope is that each year the value of the shares go up. And so the number of shares that flow back to me year over year is less. And so I will receive back $1 million of shares plus interest. So I'll keep my 12.5 million where I'm happy. I like to be 12.5 million. I'm going to stay 12.5 million. But if those shares really go up, no problem. I'm shaving it off, shaving it off, shaving it off into the IDGT or the GRAT. These are called estate freezing techniques. They are ways of how to fund the IDGT or just do a GRAT. So we can do a lot of creative things with the design of the trust, of how the trust is laid out. And then we can also do creative things about how do we get things into the trust, in addition to how do we get things out of the trust. So like that very typical client and very typical concern of saying, well, I'd like to gift it. What I really want to give the kids is the appreciation on the $1 million of stock. but I don't want to give them just $1 million, everything. I don't want to give them everything because I kind of want the million, I kind of need the $1 million. And, it's my $1 million anyway. So, I kind of just want to give them, if it really does well and, all of a sudden it goes to, 5 times the value or 3 times the value, sure, the extra, 2 times the value, they can have that. It doesn't, change my life at all. You know, I'm happy as long as I keep the million, we can do that. So these are often laid out as separate trusts or separate strategies, but actually when in real life, when you do them, sometimes they're combined into the same vehicle. It's just conceptually easier to take them apart and thinking of them as separate things. So that's a little bit of an easier way to think about them. The charitable lead trust is a little bit of a separate thing. I'm going to omit that for now. That's essentially a charitable technique to fund a trust, generally with cash, generally with assets that do not have built-in capital gain. And what your objective is with a charitable lead trust is to trigger a high charitable deduction in year one, and then the growth of the asset will grow in the charitable lead trust. The charity is, of course, receiving the lead. They're receiving the payments over the 5 years or 10 years or 20 years of the trust, and then the remainder drops back down into the trust. Since we're here, actually, I'm going to answer a question here. There's a question here for the estate freezing techniques. Will the principal and interest paid back by the IDGT or the GRAT be taxable from the income tax perspective? No, it's not taxable from the income tax perspective, providing it's an IDGT, it's a grantor trust, or it's a GRAT, a grantor retained annuity trust. The key is it has to be a grantor trust, number one. And the two thing is, with the principal and interest being paid back, you must pay it back in kind. So I put the $1 million of stock into the trust, and the trust is holding the stock. And then how it pays back the note is it pays me by transferring the shares back to me that's reflective of the number of the payment. The IDGT or GRAT cannot liquidate the shares and pay me cash. If it liquidates the shares, it's then going to basically the amount of what it liquidates, the capital gains tax on that amount, that's going to flow back to me. But the transfer of the stock in and out of the IDGT or the GRAT for income taxes is not a taxable event, because for a grantor trust, the trusts and myself are the same tax person. All of these flow back to the same return. So for IDGTs and GRATs, the key is the grantor trust. That's the distinction. Income tax, there wouldn't be a recognition of income on those transfers unless the trust sold the stock. There is, of course, estate tax issues, estate gift tax issues between that transfer, but income tax, no, providing it's structured and administered properly. So that's a good question, because that's the key thought of grantor trust. I'll just go on a little bit of a tangent here. Is a non-grantor trust, if it was an irrevocable non-grantor trust, then we have a problem. If it is a non-grantor trust, having things go in and having things go out, there can be issues of recognition of gain if and how I'm moving it back and forth between the trusts. So we have to be careful with an irrevocable non-grantor trust. That will be potentially income tax sensitive. So that would be different. So let's move on to our next thing. We spent a little bit of time on our common trust. Let's go on to slide 3 here. So this is a little bit of an extension of what we were just talking about, is techniques for how to get things into the trust or how to get things to other persons. First thing to think about is the annual gifting exclusion. The annual exclusion that you can gift per year. So per donor, per donee, $19,000 a year this year. So married couple, we can do $38,000. So we can essentially do 38,000 son, 38,000 daughter, 38,000 other son, nephew, on and on and on. So that's the first thing to think about. If you are a higher net worth family doing the annual exclusion gifting, usually a good idea. Many people joining us likely have seen this as commonly combined with an ILIT, an irrevocable life insurance trust, mainly because it's just a really elegant way to do irrevocable trust planning, is that you have an irrevocable life insurance trust, and that irrevocable life insurance trust, you set it up, the trustee buys the policy, and you just throw in the 38,000 or the 76,000 per year into the trust. And then by doing that, the value of the life insurance, the multiplier effect of the insurance, just gives you a just really large result for relatively no estate gift tax effect. So that's often paired with the ILIT, but it can be outright. If I have adult children, if I'm not insurable life insurance wise, I don't like the insurance, all those things, I could just do it outright, or I could do it to a regular IDGT. I could do that too. So annual exclusion gifting, we don't want to forget that, because that's the basically time helps us. Say, oh, Mike, $38,000, that's like nothing. Yeah, but if we do it over 10 years, that's 380, and it goes up, more or less every 2 or 3 years. That's not nothing. We use consistency there. What can we also do? Direct payment exclusions. So do remember there's an unlimited exclusion for tuition paid directly to the educational institution, or amounts paid directly to medical providers, providing it's not cosmetic in many situations. But payments for these things, these are direct exclusions. So we can pay for education expenses, all of those things. Do make sure you are paying the institution. I had a case years ago where the person paid the kid, and the grandparents paid the grandson, and then said, okay, grandson, just pay it over to the institution. He was a good grandson. He did it. But it's like, whoa, that's not the way that works. That's a two-step gift, and you're not going to get an unlimited exclusion for those gifts. So make sure if you're using the direct payment exclusion, you're directly paying. It has to be a direct payment. If it's not, that's not going to work. So be careful, because that can be a common trap. The other thing I want to drop down to is charitable remainder trusts. These have been wildly popular the last few years, mainly because they are just so useful here. What's the charitable remainder trust? This is a great vehicle to convert highly appreciated, low basis assets into a diversified portfolio and then an income stream, while also generating a partial charitable deduction. So this is something that, if I have, model case, my favorite case, and we have these not infrequently, is I have a whole lot of tech stock, mainly from my company. And it's fantastic. It's a nice problem to have. But I am all stuck in that one particular stock symbol. And today I'm happy because this market's up. But like last April, I was like, indigestion and taxes, and then my portfolio's tanking. I feel terrible. I wish it was diversified. That's what the charitable remainder trust can do, particularly if you're close to retirement, or you have a time horizon of when you want to stop working. You can create a charitable remainder trust, where I create the trust, I throw the stock in, the trust immediately sells it and diversifies it, and then it flows a stream of income back to me for my lifetime or a term of years. So generally no longer than 20 years or my lifetime. So I can have the 20-year term, and then it flows it back to me 1/20th per year, and I pay taxes on the flow out, the 1/20th. So I would have paid taxes on 20/20th, one whole, but instead I'm paying taxes on 1/20th over the lifetime of the charitable remainder trust. I also get a tax deduction for about maybe 8 to 12% of what I put in. So it's a great way for me to say, oh, I got out of that stock symbol right away. I wasn't stuck in it. I had a diversified portfolio. And then I started to take a stream of income that lasted over 20 years. Even more solutions with the charitable remainder trust we can tailor. We say, well, wait, Mike, I'm still going to work for 5 years. I'm not going to retire for 5 years. I don't really want to get the income now for these 5 years. Should I wait for the charitable remainder trust? Say, well, you could, or you could design a charitable remainder trust with a flip, with a toggle, and where I say, okay, I'll create the charitable remainder trust. It'll be a 20-year trust, but no payments for the first 5 years. 5 years passed, and then it flips, and then it flows the payments out right at retirement time. We can do that. And it's like, oh, so I can get diversification now. I can get the charitable benefit now, and then I don't get the flow of income for 5 years, and then it flips, and then it flows it out. Yeah, we can do that. So charitable remainder trusts, they can be an attractive tool for dealing with this stock. It works exactly the same way for highly appreciated real estate, that perhaps the real estate has highly appreciated, and more critically, which I often see with the real estate, is I've depreciated all the basis out. Rental real estate, if you just got done with your taxes, residential real estate is a 27 and a half year life under ARR. So 27 and a half year life, if I had it, 20 years, I've depreciated much of the basis out. So even though the basis, I bought it at an okay time, I basically enjoyed all of the basis. If I sold it, I would have substantial depreciation recapture, not attractive. Well, maybe I throw that into the charitable remainder trust, sell it, and then avoid that issue of the significant depreciation recapture, because I can spread it out. So that all is kind of the key things on slide 3. Let's take a look at slide 4 over here of some international and cross-border things. What I will, let us set this aside. This is a little bit changing gears a little bit too much. Let's go to slide 5 here. We can always come back to this if we have time. This is the thing that I wanted to take a look at, because I'm seeing these problems, particularly at tax time, when things are getting filed and our partners and colleagues are taking a look at the tax returns, and we're having to make sure that things are done correctly. What are some of the things that I see as big problems? This actually I haven't really included on here, but it is an overarching question here, is the filing of the estate tax return. So, and in fact, there's actually even a question that someone posed on this, is that if something happens to my spouse, and we're a married couple, when someone passes away, there's 9 months to file the estate tax return. It can be extended for another 6 months, but all elections have to be done in the first 9 months. So if the unfortunate happens and something happens to a spouse, it's a very difficult time, especially, this may be happening to people around you. Very challenging time, but it is important to see the attorneys and get the estate tax prepared, make the appropriate elections in the revocable living trust, and get it filed, or at least get those things nailed down and signed before a notary in the 9 months. If I want to disclaim to a bypass trust, if I have an ABC style trust, if I want to disclaim to the bypass trust, sometimes known as the family trust, because I want to move the asset in there at the low valuation, or I just think it's going to go up, that has to be done in 9 months. And it's done by doing an estate tax return in the 9 months, or 16 months, or I'm sorry, 15 months after the person dies, but the elections have to be done. So portability, so that is required. It's also required if I just want portability. So if I say I'm not doing any elections, I'm not doing anything complicated, you need to file an estate tax return. It's generally due 9 months after the person passed away, extendable for another 6 months. But, and this is a good thing, if I forgot to do this, I say, oh, Mike, I did not do that. That was a very difficult 2 years for me when that happened. And I have many clients with this situation. I couldn't imagine, if something happened to my spouse, what I would do. 2 years, yeah, we probably couldn't get over it. So that's normal. The IRS has a solution. They say, we understand. Oddly enough, the IRS, they get this. They say, we get this. If you didn't file it and you're just doing portability, you're not doing anything fancy. You're not doing an election to fund a bypass trust. You're not doing anything fancy. You're just doing portability. American citizens, just portability, we'll let you have 5 years. There's a revenue procedure. You have to fill out the return and mark it specially and mark all the revenue procedure all over it and say, filed late under the revenue procedure, they'll let you have it. Because, oddly enough, they kind of get it. It used to be actually only 2 years, but the revenue procedure got better. So got to file that return. So that's the important thing. The other thing is just proper administrative attentiveness, the fiduciary duties of the trustee. You actually have to, if you're named as a trustee, administer the estate properly. This is one that I came across. This is letter A on here. Is I had someone with they were the trustee of a trust for a non-citizen, non-resident, and we said, there's significant, very significant estate taxes due. This was not set up properly. This revocable living trust. There's estate taxes due, and the trustee said, "Oh well, that's probably not going to be a big thing. I'm just going to give the money to the beneficiaries and basically not file the estate tax return. And if there's any problem, if the IRS catches us, they'll go after the beneficiary." I said, no, Treasury Reg 2002, 1, they go after you. They go after you. They don't go after the beneficiary. They're going to go after you because the beneficiary is not in the US. You're the trustee. You're on the hook. So, it's your risk, buddy. But I wouldn't do that if I were you. This is also thinking through if you're the foreign person. Structure it better because you put the trustee now in a very awkward spot because the trustee's like, the family wants the money, but the taxes are really high. And they say, nobody's going to notice, but if somebody notices, I'm going to be the one who has to pay it. That's not good. That needs to be structured better. Valuation disputes. This is another one. This one's D. I just want to mention D here. I'm getting this a lot for transfers of different things. Just pay for the appraisal. Get a good appraisal. If you're moving things in and out of trusts, or you have a trust that needs to be administered, you do need valuation professionals. So valuation professionals are necessary because if you have valuation professionals and they meet the Treasury regulation requirements, their valuation is generally, I wouldn't say presumed, but generally deemed reliable unless it's just facially wrong. So you want to do that because if you just sort of guess the numbers on this for a gift tax return, it's not considered substantial disclosure. So on a gift tax return, the statute of limitations never runs. So on a gift tax return, you don't really want to do that because you can't start that clock, which is the whole point of the gift tax return. And then for estate tax returns, they're frequently audited. So you generally want to do that there. So that's things to consider for estate tax or for estate administration. There's also, of course, the installment sale, but this is a little bit of a nuanced thing. This is where if taxes are owed, you can sometimes do a sale to ameliorate that. But we'll kind of set that aside. In our last about 8 minutes, I'll take a few. We have some written questions that came in. And perhaps we could go to the last slide and just leave it up a little bit just for our contact information, how to contact me. I didn't give a detailed intro of who I am. I'm Michael Lee. I'm one of the partners and founders of RUI Attorneys. I'm an estate planning attorney, licensed, of course, California, Washington, Nevada, Wyoming, and Washington, D.C., which doesn't come up that often. So a few questions that I'll just take that got written in here. One, there was a question about if someone gifted $10 million, I gift $10 million out, and then later the exemption is reduced to $7 million. What's the implication of this? Well, under past law, under the Tax Cuts and Jobs Act, and the current law, there is no clawback. What's clawback is I do the gift and it's under the high exemption time. So I gift out, let's say, $15 million, and I gift it out, and it's fine. It's gifted out, and then I still have $2 million left, and then I live my life, and the estate tax exemption goes down to $10 million, and then I die. Okay, I'm definitely going to have tax on the $2 million, but do I have tax on the 5 that I had previously gifted? Present law and under Tax Cuts and Jobs Act, no. There's no clawback. There's no looking back at the gift that was done lawfully. And by, I should say lawfully, I would say properly in line with the exemptions at that time with a properly filed gift tax return. There wouldn't be clawback where it gets taxed later. That goes back to my point, though, again, with you need to have a properly filed gift tax return. And if you were gifting something like a house, or you were gifting something that did not have readily ascertainable value through a public market, like stock has a regular market with readily ascertainable values that I could just use the high and low of the day and average it. That's generally what you have to use, the high and low price of the day and then average it of the day that you transfer it. That one, you can just calculate yourself. But if it's anything else, you need a valuation professional. Going on to a few other questions. There's a question, can foreign nationals set up ILETs to avoid estate tax? Yes. That's actually frequently done. Foreign persons establish U.S. irrevocable life insurance trusts, mainly so that they're not the owner of the asset. It's actually a little bit complicated. I should say complicated, but insurance on a non-U.S. person's life generally isn't subject to estate tax, but the container of the ILET is very valuable to properly administer the life insurance policy. If the question is, can a foreign person establish an intentionally defective grantor trust? Yes, but it's more complicated. Generally, that becomes a foreign grantor trust where the trust is a foreign grantor trust with a defect as to U.S. situs, and then it approaches the U.S. with a state tax blocker company. So you have an estate tax blocker company and you have the trust over it. That's the way that you'd usually do that. So that's an issue there. For international, there's some question about international best practices to pass large estates to U.S. Children. One of the main things, this is a complicated one, we could take the whole time. Really what you would have to do, make sure everything was settled up in the foreign country so that there was efficient passage of the assets under the foreign country's law to, let's say, the U.S. grandchildren. That's step number one. And I say U.S. grandchildren, it could be U.S. grandchildren, or think about this is, do you queue up, and we do this actually more frequently, the large inheritance from abroad of the non-U.S. person is going to flow to U.S. irrevocable trusts for the grandchildren. And so it's foreign, not to the grandchild, it's going to be foreign to the irrevocable trust that was set up for the grandchild, let's say Nevada, Wyoming. That will flow under the laws of wherever. It will then pass through. It will land in the United States in the irrevocable trust for the grandchildren, or perhaps even the dynasty trust. It will land at that time, and then the trust will file a 3520 to report the foreign inheritance, and then you're good to go. There's a lot that can be done with this, and it often involves sometimes we call it a receiving trust. That trust may be empty during the lifetime of the grandparents, except for $1 to create the trust. But it's basically a big basket that we say when something happens, that all is going to flow into this basket, this U.S. basket. So that's usually good. Some questions about what if a US person receives a substantial gift from abroad. If a US person receives a substantial gift from abroad, they generally need to file a Form 3520 to report receipt of the gift. So they need to report, like, why did you get all this money? Where did this come from? What is it? You say, it's a foreign gift or it's a foreign inheritance. Okay, good. But then the question is that smart? Just like I mentioned before, of like inheriting from the foreign grandparents. If someone from abroad, if I'm a US person, I'm just Mike Lee, let's say I'm single, and I receive, $30 million from France, or, $20 million from Spain, or wherever, and I receive this, you do realize you blew the estate tax exemption with regard to me. So I actually am now $5 million or $15 million over the estate tax exemption. So if I die, I'm exposed 5 million to another 15 million to a 40% tax. Not a right way to structure it. Maybe I should give 5 million to me as spending money, and my foreign person should gift the other part to an irrevocable trust for our heirs forever. That would probably be better. Because that will never be subject to estate tax, because that money was magic money from abroad that was never subject to the estate gift tax system. So we have to kind of think through how we would be setting it up. So I'm happy to see some lively comments. Alas, it's 1 p.m. We kind of have to leave it here, but I hope this was helpful for everyone to really think through carefully our lay of the land, what the US estate gift tax system is like, the opportunities that it is higher now. So we have more opportunities to gift and move things around. Thinking through also what we can use, if we can use these irrevocable trusts, maybe IDGTs, and then we can add sort of modules to them, add a dynasty module, add a sort of slat module, or I'm going to have a funding module because I'm going to do a sale, and I can kind of stick these things onto it to really optimize it for what I'm trying to do. We can do that. And then just remember the housekeeping things of filing the appropriate tax returns timely, because things like the estate tax return for the passing of a spouse, that needs to be done for portability. Gift tax returns, that needs to be done so that we properly disclose the gift and set the statute of limitations and set the value. That's the key thing, like with the gift tax returns, is that you file the gift tax return, you just guess the valuation. I mean, people do this, but they shouldn't. They just guess the value. That doesn't set the statute of limitations. The IRS can always come back and say, wait a minute, it wasn't $1 million, it was $6 million, and then argue about it. So you want to do it properly so it actually closes the year. So filing the appropriate returns. And then the last thing, of course, we hope working with professionals that you like and are effective to give you the best results. And feel free to email, telephone, text, WeChat, all of that. Feel free to contact us. And then we look forward to seeing you next month, where we'll have another of these. Feel free also, if you are interested and like these, if you have topics that you like, email or let us know. And if we get kind of a crowd source of topics that you like, we'll focus more on that. If people say, oh, what I really want to talk about was that slide 4, Mike, that you kind of skipped, if we get consensus, that's where we'll go. So it's great to see you all. And at 1:01, we will call it a day. Be well, and I look forward to seeing you again next month. Goodbye.